Good afternoon, all. I think we are good to go. Firstly, by way of introduction, I'm James Nicholls, a partner in the Global Risks team here at DWF, and I'm going to be talking to you today about arbitration headaches, prevention, symptoms, and cure. So thank you very much for joining and for giving up your lunch hour. Now's the time for the customary pause and pray while I try to share the slides. While I do this, a couple of housekeeping points. I'm very happy to deal with questions as we go. There'll also be a slot for questions at the end, so whatever works best for you. And I should apologise at the outset because although this talk is headed Prevention, Symptoms and Cure, given the nature of these issues, they are quite heavy on headaches and slightly light on prevention and cure. So with that qualification, what am I going to be talking about today? Well, firstly, I'm going to look at conflicts, conflict positions that can arise in London arbitration on the arbitrator side, before going on to questions of consolidation and joining third parties, before concluding with a look at a couple of quirky arbitration agreements that I've encountered over the last few years and the impact that drafting and clauses can have upon the efficient running of an arbitration reference. So firstly, we turn to conflicts. Now, arbitrator conflict is a topic that is current. It has been before the courts in recent years, and the courts have legislated to deal with conflict in the form of the Arbitration Act 2025. So I'm going to run through the English law position. I'll again provide a case study on a claim that cropped up that I was involved in the COVID years, before moving on to the practicalities of dealing with conflict. Now, the fundamental principle of London arbitration is that the tribunal is neutral and entirely impartial. In this way, London arbitration differs from US arbitration, where a party-appointed arbitrator is expected to advocate on behalf of the party, and the chair then determines contentious issues. Here, the impartiality of party-appointed arbitrators mirrors that of the third arbitrator, and the courts have held that impartiality is a cardinal duty for arbitrators that they must observe upon appointment. However, inevitably, and this means no disrespect to the arbitrator community, but typically arbitrators have been deeply ensconced in the industry in which they arbitrate. That's certainly the case in London market insurance and reinsurance disputes. There is typically only a small pool of arbitrators, and they typically have a complex web of relationships within the industry. And so inevitably conflict issues do arise in practice, and we'll go on to look at some of those. As ever, when looking at arbitration, the starting point as a matter of English law is the Arbitration Act 1996. And I've included here a couple of provisions that predated the amendments that we've recently seen under the 2025 Act. That's not surprising, because Section 33(1) sets out that fundamental principle that a tribunal shall act fairly and impartially as between the parties, giving each party a reasonable opportunity to put his case. So far, so good. Section 24(1) includes the means available to a party to an arbitration that has a grievance over conflict. So this sets out the mechanism whereby, if there are circumstances that exist which give rise to justifiable doubts as to an arbitrator's impartiality, a party can apply to court. And I will go on to talk about the pros and cons of taking that step. My sense is it's a fairly nuclear option available to a party, which can have damaging consequences for that party. As mentioned, the courts have looked at questions of conflict. The leading authority here is the decision of Halliburton and Chubb Bermuda, which was heard by the Supreme Court in 2020. So a bit of background on this case. It concerned a coverage dispute under a Bermuda form contract rather, in connection with losses that arose under the Deepwater Horizon incident. Halliburton issued arbitration proceedings against Chubb, and a disagreement between the parties arose as to the appointment of the third arbitrator. Chubb proposed the appointment of Kenneth Rokeson KC, highly respected barrister, who, as the facts of this case show, was instructed broadly across numerous references. However, Halliburton had difficulty with that, and they refused to agree to Mr. Rokeson's appointment on the basis that the dispute arose under a Bermuda form contract. That contract was governed by New York law, and so they said it would be inappropriate to have an English barrister sit as the third arbitrator. The parties couldn't resolve this disagreement, and so they went to court, issued an application under Section 18 of the Arbitration Act, by which the court can appoint in default of agreement. And the court endorsed the appointment of Mr. Rokeson. This was in June 2015. There were developments, though, after his appointment. In December of that year, Chubb appointed Mr. Rokeson in a separate arbitration. Now, this arbitration also related to the Deepwater Horizon incident, but it was brought under a policy which shared the same form as the Halliburton policy, but it was sold to a different insured and concerned different issues. Shortly after that, in 2016, the other insured concern, Transocean, appointed Mr. Rokeson in an arbitration against a different insurer, but under the same layer of cover. So we've got a bit of entanglement here, shows how popular Mr. Rokeson was at the time. A complication arose, though, in that he failed to disclose to Halliburton his appointment in the later two arbitrations. Halliburton only learned of his involvement belatedly, and they complained about his continued involvement in arbitration 1 against Chubb. Mr. Rokeson refused to step down. He took the position that he had been appointed by the court, that the later references, the later two arbitrations, concerned different issues, albeit they're related to the same incident. And finally, they were to be heard as preliminary issues. And he took the view that there would not therefore be an overlap in the evidence before the tribunal in the Halliburton case and in the later two arbitrations. Halliburton were deeply unhappy with this, and so they took the matter to court. They issued an application under Section 24 that we saw earlier, seeking to have Mr. Rokeson removed as the arbitrator. And the grounds they gave were that there was essentially a knowledge imbalance. Halliburton maintained that Chubb had an unfair advantage because Chubb could use their knowledge of how Mr. Rokeson reacted to submissions and evidence that was before the court in the later two arbitration references to their advantage in the Halliburton and Chubb case. They maintained that he was not in fact biased, but he may be suffering from unconscious bias on the facts of the case. And credit to Halliburton's tenacity, they took this application to the commercial court, appealed it to the Court of Appeal, and appealed again all the way up to the Supreme Court. And the Supreme Court looked at two separate issues. Firstly, the question of bias, and secondly, the question of disclosure. So dealing with bias first, the court set out the principle here that a party-appointed arbitrator is expected to come up to exactly the same high standards of fairness and impartiality as the chair. And the court went on to set out the relevant test, which is to ask whether a fair-minded and informed observer, having considered the facts, would consider there to be a real possibility of bias. So that is an objective test. And in applying it, given the reference to the facts, the particular features of the arbitration must be considered. Now, in this case, the court held that there was no, that there was not a real possibility of bias. And that decision was informed by a number of specific factors. Firstly, the court held that the position under English law at the time of disclosure was uncertain as to an arbitrator's obligations. That position has, of course, changed since the 2025 Act. The court held that the sequencing was relevant, and in particular, the fact that the two arbitrations concerned followed Mr. Oakerson's appointment in the Chubb and Halliburton arbitration. The court agreed with Mr. Oakerson's point as to evidence and the fact that the two arbitrations were to be heard as preliminary issues. So the extent to which the evidence in one might contaminate the other was low. And finally, the court held that Mr. Oakerson acted entirely properly and that there was no possibility that by virtue of being drawn into the Section 24 application, he would have held it against Halliburton. So Mr. Oakerson remained in post. The second question, though, concerned whether or not he should have disclosed his appointment in arbitrations 2 and 3 upon being approached. And interestingly, in considering this question, the court took into account the particular nuances of the market. This was a Bermuda form dispute. The court held that there was no custom and practice as to disclosures by an arbitrator in the context of Bermuda form policies. And so Mr. Oakerson should have erred on the side of caution and made a disclosure to Halliburton. Interestingly, the court this was the Court of Appeal actually, drew a distinction between the Bermuda form example and a reinsurance dispute heard in the context of Arias rules, where the court held there was a custom and practice to the effect that disclosures are rare, and that reflects that there is only a very small pool of arbitrators available in the reinsurance world. That wasn't the case, though, in the Bermuda form context. And in fairness to him, Mr. Oakerson acknowledged and conceded that he should have made a disclosure at the relevant time. And one would hope that, given the legislative changes that we've seen this year, that situation wouldn't arise again. And I've included here an extract from the Arbitration Act, Section 23A. This was introduced into the legislation under the terms of the Arbitration Act 2025. And as we can see under subsection 1, a potential arbitrator, so a nominee, is obliged to, as soon as reasonably practicable, disclose any relevant circumstances of which he or she is or becomes aware. And the definition of relevant circumstances is included under subsection 3. It means those circumstances that might give rise to justifiable doubts as to the individual's impartiality. And in that respect, the legislation reflects the fair-minded and informed observer test that was set out by the Supreme Court in the Halliburton case. We can't ignore subsection 2. This deals with a situation in which a serving arbitrator becomes aware of relevant circumstances. So this really deals with, this section of the Act deals with two situations, one in which an arbitrator is approached, and the other, which is the Halliburton situation, in which a serving arbitrator learns of circumstances which may give rise to concerns about impartiality. Now, I'm conscious that the law is all quite dry, so I thought I would include a recent example of an incredibly difficult conflict issue that arose in connection with COVID liabilities under reinsurance contracts. I should start by saying that all of this information is publicly available, but you can see I have some nervousness in naming the individual concerned, who I've cryptically called DKKC. I'm sure that many people can figure out who it was, but nonetheless, that's my halfway house. Bit of background here. DKKC was appointed as an arbitrator in a dispute under a property cat cover, which concerned coverage for business interruption losses that followed the COVID-19 pandemic. That claim was brought by Cavere under its property cat contract against its reinsurer Unipol. As you would expect of a busy and successful Silk, DK acted in other COVID claims, including one which arbitrated, which was materially very, very similar to the Covéa dispute, albeit it arose under an entirely different contract written in similar form, which was sold by Genry to Markel. The two disputes had different outcomes. I should say, the two issues that were concerned were firstly whether or not the outbreak of COVID can constitute a catastrophe, and secondly whether an hours clause in a reinsurance contract operates to shorten or rather reduce indemnity payable under the contract. Now, those two questions were answered differently by the two tribunals in the Unipol and Markel arbitrations, respectively, and they were both appealed to the Commercial Court under Section 69 of the Arbitration Act. The court, as a matter of case management, decided to consolidate those two appeals, and the result was that the two were heard together before the Commercial Court, before a single judge, at a single hearing, and the parties effectively made submissions in turn. This put poor old DK in a pretty unenviable position, where he had to argue for his reinsurer client against the findings that he signed up to in a similar but discrete arbitral award. Now, there were absolutely no issues with disclosures here, or indeed DK's conduct, but this example really serves to show some of the complexities that can arise when you have what is a fairly tight-knit marketplace and significant overlap in issues that affect reinsurance contract A and reinsurance contract B in the event of a market-wide loss. Which takes us neatly to prevention and cure. The good news is that hopefully the codification of the arbitrator's duties and obligation to disclose by means of the Arbitration Act 2025 has brought some clarity to the law, and it has formalized the arbitrator's duties. In turn, this creates, firstly, a concrete guide which arbitrators can follow, but also a clear basis for a party that wants to object. That said, in practice, as endorsed by the Supreme Court in the Halliburton case, it is always best as an arbitrator to err on the side of caution when it comes to making disclosures. But we've just seen a atypical and unusual scenario in which the Arbitration Act would not have resolved the awkwardness that eventually emerged before the court. And what that really tells us is you can't legislate to deal with every scenario that might arise in arbitration disputes. The best that we can do, I think, is to set out guidelines, and the best that the legislature can do is codify those guidelines, and for arbitrators to take the cautious approach and refer to soft law, and I have flagged the IBA guidelines on conflicts, which includes a traffic light system by which an arbitrator can gauge whether or not they are conflicted. Now, the last tool that is available is arbitrator questionnaires, which ask the arbitrator about their relationship with the arbitrating parties and or their lawyers and their involvement in the same disputed contracts or subject matter. And I've flagged here, or rather I've included a question as to whether they are a help or a hindrance. The starting point, I think, is that transparency is or should always be a positive. And so the use of arbitrator questionnaires should help rule out disagreements as to conflict further down the line. And in fact, they do that. But there is a danger that unscrupulous parties can use them as a device to object to the appointment of arbitrators favored by the other side. This, I'm afraid, is a feature of a number of American arbitrations. It can lead to a huge amount of expense and wasted time. I have had objections to an arbitrator questionnaire lead to an 8-month delay in the appointment of a tribunal, which is not in the interests of justice or the efficient management of a case. So if arbitration questionnaires are to be used, they must be considered sensibly by the parties and their lawyers. And actually, I think the lawyers have a particular responsibility to advise their clients as to the law on conflict and what is and isn't permissible. Cure is always best avoided. Prevention wins here. I mentioned earlier the potential to make a Section 24 application to court. That is a nuclear option, and it's one that needs to be carefully considered by a party, not least because if you find yourself having challenged the appointment of an arbitrator on conflict grounds, and he or she ends up serving in the arbitration, it is not a particularly promising start to the arbitration itself. And that's not to say that the arbitrator will be biased or in any way hold the application against you, but it is a point that is better to avoid, particularly given the cost and time that can be incurred in pursuing a Section 24 application. So moving on to consolidation, headache number 2, this concerns whether or not related arbitrations can be consolidated and heard and determined together under a single reference. There is a recurring theme here, which is that arbitration is a dispute resolution process that is derived from contract. It only works because the parties to arbitration agree to it under the terms of the relevant arbitration agreement. So I'm going to run through the position under the Arbitration Act and the Arias rules before moving on to a few examples and consolidation in practice. Firstly, Section 33 of the Arbitration Act. I'm not going to dwell on this because it's not particularly interesting, but this reflects the position that the parties to an arbitration are free to agree to consolidation with the other parties, and that absent agreement, the tribunal has no power to order consolidation. That simply reflects the English law position, as you would expect. And frankly, it doesn't provide a huge amount over and above the parties' willingness to contract and frame their own arbitral process. Notably, this is the position under English law. In other jurisdictions, you might find you have a different experience. For instance, in Hong Kong and the Netherlands, the court has the power to order the consolidation of related proceedings. The English courts haven't gone that far because it's a fundamental principle that they need to respect the sanctity of the arbitral process as an independent one of court and litigation. And actually, that was reaffirmed in a decision called Abu Dhabi Gas Liquefaction and Eastern Betchel Corp. This is a notable case because there were 2 separate arbitration references with a significant overlap in facts and evidence. And it was Lord Denning in the Court of Appeal, who is a judge that strained every sinew to reach an outcome that reflected fairness, not always following a black letter to the law. But even against that backdrop, and even though it would have made sense to consolidate these 2 arbitration references, Denning found, or he said, that he had no power as a matter of English law to consolidate. As a compromise, he did order the appointment of the same arbitrator in both arbitrations in order to ensure consistency and guard against inconsistent outcomes. Moving on to the Arias rules, again, these rules reflect the English law position. Consolidation is possible, but only if the parties to the arbitrations concerned give their written consent. And so we move on to a few examples where the question of consolidation can arise. And I'm afraid you'll need to bear with me on the diagrams. These have a distinctly AI feel. I asked Copilot to draft these with varying degrees of success, as you'll see. This is one of the better ones. Here we have a hypothetical example of a classic tower of excess liability insurance contract purchased by a single insured. Now, each insurance contract governing the relationship between insured and insurer under a particular layer has its own arbitration agreement. And therefore, the starting point is that a dispute, even if it concerns the same claim under each of these layered policies, should be arbitrated independently because they arise under different arbitration agreements. The question becomes, is it in the insurer's interests to seek to consolidate those claims? Or should the insurer seek to arbitrate against insurers subscribing to the primary layer first and then pursue layers 2 and 3? Or alternatively, the insured could issue a number of arbitrations, one against each set of insurers, and run them concurrently. So, faced with this scenario, there are a number of considerations that an insured would be expected to take into account. The first is cost, and although a generalization, one arbitration tends to be cheaper than 4. And it's also fair to say that it is more efficient to arbitrate related issues in a single reference before a single tribunal when you have such extensive overlap as here we're looking at a single claim. But that doesn't necessarily mean that it would be best for the insured to sue all of the insurers collectively. There are potentially strategic benefits in not doing so. Firstly, if the insured pursues the primary insurers, they may secure an award or a beneficial settlement as against those insurers, which they could then conceivably use as ammunition to go against insurers participating on layers 1 to 3. And of course, the relevant commercial considerations that the primary insurers will face come into play. It may be that they are less keen to take coverage points that simply salami slice and reduce the amount of indemnity payable if their layer is blown. And so there's a potential commercial advantage in going after them first and pursuing the rest of the tower later. However, there are disadvantages to a primary insurer. It may be that the evidence in connection with the primary insurance is beneficial, and that same evidence doesn't exist under layers 1 to 3. So in those circumstances, it would be for the insured to seek consolidation. Of course, they need consent and they may run into difficulties there. But these are the types of issue that the insured needs to consider. Finally, it's worth noting that the insured may find a degree of cooperation between the insurers on the various layers. They may talk behind the scenes on a common interest privilege basis. And so the independent treatment of each contract could well be a disadvantage to the insured. Not a straightforward question. In the second scenario, this is where Copilot went a bit wonky. We've got an odd line from the scene, but let's ignore that. Here we have a reinsurance treaty. We have 4 reinsurers with independent lines in a subscription market. The strict position as a matter of English law is that each reinsurer will have a several share. They will have a separate contractual bargain with the cedent under the treaty. And absent provisions to the contrary, separate arbitral proceedings could be brought against each of the reinsurers. Now, looking to the potential benefits and disadvantages to the cedent here, again, you've got the cost and time disadvantage of pursuing a number of reinsurers in different arbitrations. However, this approach may help seeking to split up the market. As many on this call will know, divide and conquer is a tried and tested approach to reinsurance recoveries. And finally, you have the same question about access to evidence. It may be, for example, that there is an unhelpful email exchange between the cedent and reinsurer A prior to inception that reinsurer A would deploy in order to decline cover, but no equivalent email as applicable to reinsurers B, C, and D. And in those circumstances, it may make more sense to try to exclude reinsurer A from the wider arbitrations. I should add that this is a fairly unusual scenario, firstly because of arbitration agreements providing for consolidation. Also, lead follow clauses may preclude this outcome. And finally, typically you will find consolidation because of the overriding importance of cost and time. But it's a point worth flagging. Slightly different scenario here under the third example. Here we have a cedent that has bought separate cover on an annual basis from 2020 through to 2024. And let's assume that for whatever reason, we have different participating markets on each year of cover. and an allocation issue arises. So the cedent, for instance, might want to spike losses to the 2020 year of account because it has a higher limit under that year to the exclusion of the wider years. Now, in that scenario, would it be in the cedent's interests to try to exclude reinsurers under the renewing years? Well, the short answer is probably not, because the cedent would then be faced with a scenario in which they have many more reinsurers under separate contracts saying that 2020 should respond. Whereas if we look from the reinsurer's perspective, a reinsurer would likely prefer to defend the claim to its year 2020 by saying that the loss should be allocated to different policy years without having troublesome reinsurers that participate on those years objecting. There are fewer voices against their submissions and against their presented case. And again, returning to the theme, because of the need for consent, if reinsurers subscribing to the 2020 year do not agree to consolidation, then that is the answer, and the arbitrations will need to be heard separately and independently of each other, of course, running the risk of inconsistent decisions. Now, this is the last example that I thought worth mentioning. You can have, over the last few years, we have seen large industry losses that give rise to common coverage issues under a huge range of insurance or reinsurance contracts. And the question that arises is whether or not in those circumstances you can have an equivalent of an arbitration test case. Now, I'm conscious that's entirely the wrong expression because arbitration will not be binding, but it gives an idea of the concept of multi-party arbitration. And in fact, we saw an example of this in the context of BI COVID claims to direct policies brought by 400 policyholders against Hiscox, who sought to arbitrate against Hiscox. And in this case, Hiscox gave consent. And so the parties agreed to have the action heard as a single arbitration with a 3-person tribunal reviewing 4 different categories of policy. That, of course, is an eminently sensible decision on the part of both the 400 policyholders and also the insurer, because it saved having 400 identical arbitrations dealing with the same issues, and again, potentially reaching different conclusions. But the question that arises is, if you are going to take this approach, why not agree to dispense with arbitration entirely, which it is open to parties to a contract to do because it's a consensual process under agreement, and instead go to court and have the benefit of binding precedent? Now, there is, of course, an argument that in the context of arbitration, the parties have privacy, and it may be that neither the insurer nor insureds wanted the details of their claim to be in the public domain. That said, we can see from the facts here that the Hiscox Action Group obtained a settlement that was in line with the Supreme Court judgment in the FCA test case in June 2021 in any event, so query whether or not it was worth it pursuing a consolidated arbitration. And so we move on to questions of prevention and cure. The question of prevention is answered in much the same way as the conflict question. You can seek to draft your way around difficulties with consolidation by setting out circumstances in which the parties agree to consolidate similar arbitration references. The difficulty we have here, though, is that the drafting is an absolute pain because it's very difficult to anticipate the various circumstances that might arise in which consolidation might be appropriate. And to give an example, I've included here a consolidation provision that features in an insurance policy that recently crossed my desk. This is incredibly broad. It provides for, or rather it envisages, a potential consolidation between reinsurers participating on underlying excess or quota share layer contracts. And then optimistically, it provides that in the case of joinder, the panel shall consist of 3 members, one appointed by the company and one appointed collectively by reinsurers participating in the arbitration. That creates the potential for a significant headache because you have a group of reinsurers who will all have different interests and different commercial considerations, trying to agree on a single arbitrator. And you can imagine the scenarios that might result from the commercial difficulty associated with doing that. And I've not troubled this group with the remainder of the clause, but it continues for over a page to set out the mechanism for appointment absent agreement. So not straightforward. However, because of the principle that the parties need to consent to consolidation if it's going to take place, if you don't have consent, there is nothing really you can do as a party that wants consolidation. You are stuck with unconsolidated references that you need to fight independently. And really, this question comes down to the tension between the freedom of the parties to an arbitration agreement to enforce the terms of that agreement between themselves and to the exclusion of third parties, and the potential efficiency that can arise through consolidation. And I think it's fair to say that the freedom of the parties as a matter of English law wins out. Moving on to actually a very closely related theme, which is joining non-parties. So it is not unusual to see in the context of a coverage dispute an insured who, for instance, wants to join a broker that drafted or bought inadequate cover in the alternative to cover engaging, or an insurer that wants to seek contribution from a third-party insurer who is not party to the arbitration agreement under which the dispute is brought. It's helpful here to compare the position under the civil procedure rules as applicable to litigation and the position in arbitration. The court has broad powers under the CPR, and in particular CPR 19, to order that a person is added to a party to litigation when it is in the interests of justice to have them added to resolve an issue that is in dispute in the litigation concerned. And there is a stark difference, of course, when it comes to arbitration, whereby if you are not party to an arbitration agreement, it is highly unlikely that you'll get dragged into that arbitration. So the broker or the third-party insurer can breathe a sigh of relief insofar as there are arbitration proceedings in train. I'm not going to go into a huge amount of detail about this Marina and BHP group case, not least because it doesn't concern insurance or reinsurance. But in summary, it concerned proceedings that related to the collapse of Fundão Dam in Brazil in 2015, and litigation was brought against BHP Brazil and Vale, and they were 2 JV owners of the dam. Vale somewhat optimistically or ambitiously applied for a stay, and that was on the basis that the dispute fell within an arbitration clause in a shareholders agreement with another BHP entity in the wider group. And Vale came up with a fairly creative argument that BHP Brazil was so heavily involved in the drafting of the shareholders agreement that it assumed a role and effectively became party to it. Perhaps unsurprisingly, the court wasn't having any of it. It was held that the starting point is that it's unusual for a party to be bound to a clause which it never agreed. Again, that is a cornerstone of English law applicable to arbitrations. And so unless BHP Brazil agreed to join the arbitration, it could not be dragged in to it. The final question that arises is, why would a third party consent? And here I'm straying into potential questions of how E&O insurers deal with their disputes. This is taking the broker example. In my experience, a broker that is arguably involved in drafting a wonky policy or has failed to buy the right cover on behalf of their client, they tend to keep out of disputes on coverage and only step in once that dispute has gone against the insured or the reinsured that is claiming indemnity. However, there are reasons that a broker in that circumstance might want to join, The main one, of course, is the privacy that's afforded by the arbitration process, and the fact that a target to a potential negligence claim will not want to wash its dirty linen in public. And I'm not sure who is on this call. I can't see on my screen, but obviously this is a hypothetical, and it's extremely rare that those types of broker involvement arise. So finally, we get to a couple of examples of quirky arbitration agreements which had pretty profound impact upon the arbitrations concerned. The first concerns a governing law clause which featured in the context of an arbitration agreement. And this concerned, I should say, the governing law of the contract, not the governing law of the arbitration clause. And it provided, in case defendant party, slightly dodgy drafting there, is the reinsurer, the applicable law will be Slovenian law. Otherwise, in case defendant party is the reinsured, the applicable law will be the law of England and Wales. And I'm sure you can see the difficulty here. In this case, there became a race to issue proceedings. The Slovenian cedent wanted to issue a claim, a monetary claim for recovery and indemnity under the policy, on the basis that if it did that, Slovenian law would apply to its advantage. Whereas our clients, the reinsurer, wanted to issue an arbitration for a declaration that there was no cover, because then it became the claimant to the proceedings and English law would apply. Now, as we know, arbitration, or indeed litigation, should always be a last resort in the absence, having extinguished all other possibilities to resolve a dispute. Unfortunately, this clause cuts against that principle and encourages dispute, under which the parties try to take advantage of the varying applicable laws. So that is one that I would recommend avoiding. I haven't seen it since that case, actually, so I get the impression it's not been picked up more broadly. The second and final example concerns baseball arbitration. And this is a concept that comes from the States. In Major League Baseball, apparently where there is a dispute over a player's salary, the player and the management of the team put forward their own proposal as to what the player's pay should be. The two proposals are then put to an arbitrator who makes a binding judgment as to the pay that should apply, and the parties then have to stick to that judgment. We have seen a similar formula in the context of arbitration under a reinsurance contract, which provides that each party to a dispute needs to set out its case and in the same document submit proposals, which is followed by a single-day hearing, following which the arbitrator chooses either Party A or Party B's proposal. It's essentially a sealed bid process. The advantages of this approach are, firstly, it encourages a degree of realism on the part of Party A and Party B, and it guards against, on the insured or the cedent's part, inflated claims, and on the reinsurer or insurer's part, unreasonable declinatures. It's also a streamlined process, and I've put this under advantages. Obviously, if you have a complex coverage issue, then a one-day hearing, and I think in this context there was a 30-day period for putting proposals to the other side, is not appropriate. Whether if the parties are most focused upon efficiency and cost, then this isn't a bad way to go. And the final consideration here is that it arguably reflects litigation risk, because more often than not, both parties will come away with something. And I have spoken to clients in this market who quite like the idea of baseball arbitration, because in their view, it reflects what is quite commonly the outcome of arbitration anyway, i.e. splitting the baby. That said, I don't like it. Call me a purist. Firstly, it's a very odd concept, which is almost an arbitration and mediation hybrid. And although strictly speaking, it's not ADR because the arbitrator comes up with a binding determination, it sits uncomfortably with the principle that an arbitrator should have power to determine a dispute as it sees fit. It's also clearly inappropriate when you have a claimant that is seeking non-monetary relief. It is a money-led process whereby the two parties put a figure on a piece of paper and the arbitrator chooses one or the other of those. And finally, it has the potential to lead to abuse. And if you were, say, an unscrupulous insurer, you might look to decline cover under a contract that provides for baseball arbitration in the hope that the insured will knock off a few quid in its proposal. That's not something I've seen, and obviously it wouldn't happen in this market, but it is a risk associated with baseball arbitration in principle. I don't have a question slide, but I'm very happy to deal with any questions. And before checking if we have any, I think questions, I should have said at the outset, I think questions can be submitted through the chat function. I should add that for anyone on the call who is not a member of Arias, we would encourage you to please visit the website and consider signing up and getting the benefits of membership. So this is the point where I think I need to unshare and see if we have any questions from the group.